to deal with my Lord Stephen's point about the inheritance tax that was raised before the short adjournment. The position is this, that the judge, of course, didn't make an order for sale, and if there is a buyout, then it will not have inheritance tax ramifications. So if the property is bought out and the parents carry on owning the farm, then there's no reason, subject to the appropriate conditions being met, as to why APR won't be available. If there does have to be a sale, one is entering, in our submission, into the realm of speculation, because, of course, the sale proceeds could be used to invest in further agricultural property. They could be used to invest in woodlands. There are all sorts of tax planning and estate planning methods that could be undertaken. So it's our submission that although a sale may have that result, that's not what the court ordered. It did order that the money be paid out, while recognising a sale might be a possibility.
There's a chance then that
Yes.
Ross and Jen will suffer the
Yes.
burden of tax that Andrew won't. And if there is a buyout, then will the provision assist Jen if she's not a farmer?
Yes, in passing a part of the farm to her. It depends what she inherits.
Yeah, in passing even if she's not a farmer, she benefits, does she?
Yes, but she wouldn't be entitled if she inherits some of the land.
She wouldn't be entitled to?
She would be entitled.
Sure.
The APR effectively attaches to the property that's passing to her.
Yeah.
Whether she in turn would be able to claim APR would depend on her farming, which it's anticipated.
If it's sold and they reinvest in a business asset which qualifies for APR, would there be a qualifying period for which it had to be held?
Yes, it would be 2 years.
2 years. So there'd be a 2 year period in which there was a risk of a death.
Yes.
And then IHT would attach even if they had bought woodlands or...
Yes, Milady, that is undoubtedly the case, but it's very difficult. And there are also various nil rate bands that are available. There will be a double nil rate band available for Mr. and Mrs. Guest Senior, and also potentially the residential nil rate band might be available depending on how the money was invested. It's very difficult to speculate as to what the position might be, but it won't be, we accept, as straightforward as it is now.
And Ross and Jen, of course, bear all the burden, or all the risk for the future. That is a risk of old age and care costs consuming the assets, and also risks of business failure. Not that there's any suggestion of that in this case. No. They bear all the risks, while Andrew doesn't.
My Lord, they do bear that risk, but that is because of the need for a clean break. And it's our submission that a clean break often in lots of different circumstances, whether it's a divorce or whether it's the winding up of a partnership, often creates problems that the family wouldn't have wanted and perhaps have spent years guarding against. But it's not a product in our submission of the way in which the law of proprietary estoppel works, but a function of the breakdown in a family relationship, a very sad breakdown in a family relationship. So, and to deal with the order that the judge made, there was, of course, I think, as I said before the short adjournment, the 50% of the business that was awarded was something that Andrew was entitled to in any event. There was also the fact that he was required to bear any tax that was caused by a sale, and of course there was the life interest in the farmhouse. And of course the promise that the judge found was that it was a promise that he would have a substantial share in the land, enough to carry on farming. And so it's not as if that was 40%. It might have been more. A substantial share might have been more of the land. And so that, in a sense, also is not simply the judge in this case vindicating expectation.
But what is the judge doing in this case? What is the conceptual rationale for awarding, trying to replicate a promise that is not a contractually binding or legally binding promise? Because the starting point is this isn't a quasi-contract. So why do you try and give somebody what he would have got if there had been a binding contract when there isn't one?
Because it's our submission that proprietary estoppel comes in to make otherwise legally unenforceable promises enforceable as a result of the claimant's detrimental reliance. That is the root of the doctrine, that a promise that it isn't otherwise contractual would remain unenforceable. But once there is detrimental reliance on that promise, then it becomes enforceable. And what the cases have focused on, in our submission quite rightly, is that promise.
Well, how does that reconcile with the fact that promissory estoppel, which is normally the doctrine that's regarded as giving rise to legal obligations when there's a promise that's acted on to somebody's detriment, is not capable of creating new rights? So how come you can have new rights created in property when you can't have new rights created by detrimental reliance on anything else?
Because essentially this is it's a different species of estoppel, and there have been some commentators who have regarded this as perhaps inappropriately described as estoppel, but it is wedded in the concept, or the equitable concept, of conscionability, so that if somebody makes a promise, they can choose whether that's not legally enforceable. They can choose whether they comply with it or not. But in circumstances where somebody has relied on that promise to their detriment, then equity will step in. And the early cases certainly, particularly I'm thinking of Plymouth and Wellington, talk about vindicating the promise. They talk about giving effect to the otherwise legally unenforceable promise.
But why is it equitable to enforce a promise if that which wasn't legally binding, when if that involves doing more, then we'll be required to make sure that the person has not suffered any harm as a result of their detrimental reliance on the promise? Why doesn't that remove the unconscionability?
Because we would say that the doctrine is about enforcing the promise. And what has come into the law in terms of the proportionality concept is a recognition that enforcing the promise is not always necessary in order to relieve against the unconscionability.
Well, how do we decide when it's necessary to enforce the promise and when it isn't? It isn't a binding promise in the first place, so, what's the test?
Well, my Lord, the test is this, that the court has to say, looking at the detriment that has been suffered in reliance on the promise, the court has to say, at a particular point, is it now unconscionable for the promisor to resile? Can it be right that having made the promise and somebody having relied to their detriment on that promise, can one, and this is perhaps very important, standing back at the point at which the promise is broken, look back and say that it would be unconscionable for the promisor to resile? And that is really the way, starting from the earlier cases onwards, that the doctrine has developed as a matter of English law. So, my Lord, it's that makes an otherwise unenforceable promise enforceable. And because of that, that is why we say that that is why equity has looked at the promise, because it is the detrimental reliance which is making it enforceable. And we have to accept, because of the way in which the law has developed, that doesn't mean that in every case one gives effect to expectation. And that is clear in many cases, but particularly the seminal Court of Appeal decision in Jennings and Rice, where it is said at numerous places that, and it's at 1077, it's a case that dealt with a submission made on behalf of the claimant who had been awarded £200,000 out of an estate of over £1 million, 1.2 million, I think, at first instance, that effect should have been given to his expectations, and he should have received, if not the whole estate, at the very least the house of worth £435,000 and the contents. And the point that is made in this decision is that, in effect, it is not in every case of estoppel where the court will give effect to expectations. They have to be scaled down. And my learned friend took your lordships and your ladyships to the to various of the points that were made in this decision. But if I could pick up at paragraph 27 on page 1085 of the bundle.
Sorry, on page
1085 of the bundle.
1085?
Yes.
Thank you.
And there's a reference to Sledmore and Dalby, and it then goes on with Lord Justice Hobhouse pointing out that the equitable doctrine is necessary to consider the extent of the equity and that was created and what is in the circumstances the equitable way to give effect to it. And he goes on then to deal with the High Court of Australia in the case of Fevowen. And he goes on to cite a passage from Chief Justice Mason that says, in conformity with the fundamental purpose of all estoppels to afford protection against detriment, which would flow from a party's change of position, if the assumption that led to it were deserted, these developments have brought an underlying unity to various categories of estoppel.
Well, that seems to me to support a different explanation, which is that in some cases, the best way of preventing a detriment from being suffered is to give effect to the expectation, if you can do that. Yes. Because then you will, if it's not out of proportion to the detriment, then that will be in the circumstances where it's otherwise very difficult to quantify.
Yes. The
best way of ensuring that the person does not suffer a detriment.
Yes. And
the trouble is that's not possible in this case.
No.
In the present case.
It's simply not possible in this case.
So then one goes back to doing the best you can, don't you, to make sure there's no detriment.
Well, and my lord, this is what Jennings and Rice is about, really. It's about how the court should do that. And at 29, what is...
Just before we leave 28,
yes.
The detriment to which Chief Justice Mason is on isn't the detriment by comparing what the claimant has done with a hypothetical counterfactual if he had not been made the promise in the first place. He says it's the detriment which would flow from the change of position if the assumption were deserted.
Yes.
Which seems to be, at any rate, possibly a rather different kind of detriment.
Well,
how worse is he going to be if the promise is not performed than if it were performed, which is a completely, I think, different analysis.
Well, My lord, there are two types of detriment. There's there is the broader type of detriment, which is how the person has behaved as a result of the promise
Yes.
that has been made to them.
Yes.
In this case, we would say working for 30 years
Yes.
at low pay.
The one we were talking about for most this morning.
Indeed,
Yes.
indeed, there is a narrower form of the detriment, which is referred to in some of the cases where that it's the detriment that's suffered as a result of the promise or resiling from the promise. And quite clearly, that is the form of detriment that is being referred to
Yes.
here. And
I suppose there may be cases where that's large and cases where that's actually quite small.
yes.
Yes.
Yes, yes, indeed. But
The use of the word detriment there is ambiguous, but from this morning, following what Mr. Dumont said, we're using the word detriment to mean reliance loss,
Yes.
which is perhaps a clearer way of expressing it, because that makes it clear that you are talking about working for 30 years rather than the detriment of not getting the farm.
Yes. But my lady, I think, as I said before lunch, that there is a danger, perhaps, in looking, if one looks at Professor McFarlane's work, what he is talking about is compensating for detriment as opposed to reliance loss. So, in other words, not compensating simply for the loss that has flowed from the reliance, the working for low pay, but also taking away any detriment, whether financially computable or not,
Yes.
in order to get rid of that element.
Well, that can also be reliance loss. Reliance loss can be quantifiable in terms of a difference in wages, or it can be more intangible. Thank you.
Yes.
And is the detriment suffered by Andrew and the detriment suffered by his brother, do they cancel each other out insofar as they both relied, presumably, in the expectation that they would inherit a part of the farm? And of course, if the farm is sold, then Ross can't achieve that.
No, I mean, my lord, I don't want to delve into facts that were decided by the judge. I mean, as I understand it, there was evidence that there was less interest in farming on the part of Ross. But of course, what the court was looking at, and the court had very much regard to the fact that Jan and Ross had to inherit something. That was something that the court did take into account when formulating the remedy. I mean, this is perhaps not a case like, for example, More and More, where everything was going to one child, and there was going to be nothing left for anyone else to inherit.
But if Ross had that expectation, then he's been deprived of it by virtue of the sale of the farm.
But that might have happened, if I may say so, in other circumstances as well, and it's not suggested. It's not suggested that he had a proprietary estoppel claim. Circumstances may have been very different with him. We simply don't know. It's not the subject of findings by the court at first instance. And so dealing with the judgment of Lord Justice Robert Walker in Jennings and Rice, he deals at paragraph 45, and this is on page 1089 of the electronic bundle, with the bargain type cases, and I do want to come on to deal with those cases. And he then goes on at paragraph 46 to deal with the fact that the claimant's expectations may not be focused on any specific property. And he refers to the case of Rebasham, which dealt with the promise of the residuary estate of the testator. And he then goes on to say if the claimant's expectations are uncertain, as will be the case of many honest claimants, then their specific vindication cannot be the appropriate test. And a similar problem arises if the court satisfied that the claimant has a genuine claim, is not satisfied the high level of expectations is fairly derived from the deceased patron's assurances. So that's dealing with a circumstance where the assurances simply don't justify the expectation, or that they are uncertain expectations. And then he goes on to deal with...
Those two things are very different, though. If the assurances don't justify the expectation, then that affects the scope of the cause of action. Yes. Then you say, well, the expectation was this. You may have thought it was that, but it's not. But that seems to be a different point from the uncertainty of the expectation insofar as it was properly raised. I mean, that goes back to your point as to why this is an unenforceable agreement. It's partly because it was uncertain, partly because I don't think it's possible to contractually bind yourself to leave your estate in your will in a certain way, is it? I don't know.
Yes, it is possible to...
It is possible.
So certainly contracts to make a will are not uncommon. Well, they're perhaps not common, but they do come up in practice from time to time. So there would be nothing to prevent that happening. I will come on, if I may, to the bargain and non-bargain.
Can I just ask you then, what is it about this situation then that means this is not an enforceable contract? What is the element that's missing here?
It would be that a contract to leave property by will either has to be by deed or it has to have consideration to support it. So, and that's perhaps where, and perhaps I can deal with the bargain, non-bargain point. Perhaps the most difficult issue about thinking of cases such as this in terms of initial bargain, if I can put it that way, are that that will rarely be the case. I mean, if it really was a bargain, it would be contractually enforceable, provided formalities were complied with. And the whole point about proprietary estoppel is that one stands back from the moment that the promise is broken and looks backwards. That's really the whole, or one of the major points from Thorner and Major relying on other previous cases. So one is looking at the moment where the promise is broken, looking back, and deciding whether it is unconscionable at that moment for the promisor to resign. And so it's rather difficult to think of that in terms of a bargain, where the parties are agreeing something at the outset. And even if they did agree something at the outset, your ladyship's example, when Melanie Friend was on his feet as to the promise of a £2 million flat, if somebody came to care free of charge for somebody, that may look like a bargain, albeit unenforceable. But if the elderly person only lived for a couple of weeks, standing back at the moment where her will didn't leave the property to the promisee, that would be one of those. That would be a circumstance which illustrates the principle that Melanie Friend derived from this case earlier about the fact that the expectations have to be in proportion to the detriment. And if they're not, then the court will do something else. Something that is more in proportion to the expectations and the detriment. It won't simply vindicate the expectation by handing over the £2 million flat. And it's really paragraph 50 in Jennings and Rice, where Lord Justice Robert Walker describes a category of case in which the benefactor and the claimant have reached a mutual understanding, which is in reasonably clear terms but does not amount to a contract. And he refers to the carer who has the expectation of coming into the benefactor's house either outright or for life. And in such a case, the court's natural response is to fulfil the claimant's expectations. But if the claimant's expectations are uncertain or extravagant or out of all proportion, the court can and should recognise that the claimant's equity should be satisfied in another and more generally limited way.
Now, which type of detriment is Lord Justice Robert Walker referring to there? Is it the reliance detriment, or is it the detriment which the claimant has suffered by the non-fulfilment of the promise?
Well, my submission would be that it's the reliance detriment.
Oh.
You're assuming that the carer is not paid?
Yes.
Yeah.
Or paid perhaps under the going rate.
Yeah.
That would, yes.
And how do you calculate the reliance detriment where it's non-financial detriment? In order to say, well, it's out of proportion, you've got to arrive at some sort of figure. And so how do you do that?
Well, it may be clear in terms of the fact that the detriment hasn't lasted for a very long time. That might be the most obvious. Or, as has been made clear in the Privy Council in Henry and Henry, that the court does have to take into account countervailing benefits. So it might well be that there would be countervailing benefits, which would mean that the detriment that has in fact been suffered has really not been significant.
Assume for one moment that it hasn't lasted very long, but it has involved a major upheaval in somebody's life.
Yes.
Move from one country to another,
Yes.
Move from one career to another, and all on a basis that they can't go back.
Yes.
So how do you value that?
Well, my lord, we would say that's one of the difficulties about pinning one's colours to the mast.
But you're proposing proportionality, as I understand it, and in order to get a proportionate assessment, you've got to work out what the detriment is, and the detriment must involve non-financial elements.
Yes, and my lord, it's very much our submission that detriment does involve and regularly involves in these testamentary promise type cases. It regularly involves non-financial detriment, but
well, one way of explaining these sort of bargain cases is that you're always valuing the detriment, but where the parties have essentially made a bargain between unrelated people, that's the best measure of what is going to be the fair way of compensating the person for the detriment that they've suffered, including all its aspects, because you know what they themselves thought it was worth, for the person himself thought it was worth, and that's the best you're going to do, where they've actually done their side of the bargain.
Well, my lord, that's exactly it, and that's perhaps it's notable. I should perhaps say that Lord Justice Robert Walker has not resiled, that's the wrong way of putting it, but has stepped away rather from the bargain type analysis extrajudicially at any rate, and said he prefers the idea of a spectrum. But that would still work with your lordship's analysis, that actually the spectrum, rather, if the parties have agreed what the spectrum should look like, then that can be, that is a very good guide for the court. But to deal with the question of proportionality, in your lordship's point about the proportionality and the person who'd given up a job and moved to a different country, that would be regarded as very significant detriment, albeit of a non-financial kind, that may well lead a court to consider that it would be right to vindicate expectation in those circumstances. So it is a question, and it shouldn't perhaps be forgotten that what the cases say is that in satisfying the equity that has arisen, the court is engaged in a broad judgmental discretion. That's something that the cases right the way from Plymouth make very, very clear, that the court is not trying to look for a formula in every case in order to deal with, in order to come to a solution. And of course, that does introduce an area of uncertainty, but then the circumstances of these cases are always very different.
You're taking us to have read paragraph 51, I assume.
Yes.
The first sentence there is quite a trenchant.
I was
I
about...
imagine you would say statement of your case.
Yes, that's where I was heading, my lord, yes, because even if you have a case that's a non-bargain case, and I hesitate to use that term in a sense, it doesn't mean that the court should abandon expectations completely. And Jennings and Rice...
But that's not the half of the sentence I was looking at.
Oh.
I was looking and look to the detriment suffered by the claimant as defining the appropriate measure of relief.
Yes. Yes. My lord, absolutely. That is very much a denial, if I can put it that way, of the fact that that is the correct approach as a matter of English law. And almost every case that has dealt with satisfying the equity subsequent to this case has referred to Jennings and Rice and has referred to it with approval. So
well, you've got to read the whole paragraph, though.
Yes.
It's a bit ambiguous, but one way of reading it is what he goes on to say, because the detriment is so difficult to quantify, I read it as saying the expectation may still give you a good way into putting a figure on the detriment.
yes. But
It's important to distinguish that approach from the other way of reading it, which you might be saying, is that you sort of come up with some blend of expectation and detriment.
yes. But
Which I find very difficult conceptually myself.
Surely the organising principle is reversing the effect of the unconscionable conduct. If you've promised something and you decide, the other person having incurred detriment on the faith of that promise, and you decide to abandon that promise, then if the court is satisfied that in all the circumstances that is unconscionable, it will then seek to unravel the effect for the person involved. But in some cases, all that the unravelling involves is giving him compensation for the detriment.
well, my lady, there are very few cases where that appears to be the response of the court to that. And the cases have very much concentrated on the promise that has been made.
Speaking of myself, I can quite see that if the court perceives that the unconscionability lies in making the promise in the first place, then it would almost flow as night followed day that the appropriate measure of compensation would be to put right the detrimental reliance on it. But if the promise consists not in making the promise, but in later resiling from it, it might be a rather more difficult analysis.
Yes, and Lord, it's our submission that that is exactly where the doctrine comes into play. It is the fact that there is a promise which the promisor is not entitled to resile from because of the detrimental reliance.
Yes.
And that concept has been developed, particularly in the testamentary promise cases, into a rather more nuanced approach of saying that there has to be proportionality. It's not always the appropriate response as a matter of equity for the court to give effect to the promise, but that's always going to be the starting point.
So you say that the reliance loss, whether it's financial or intangible, is important at two stages. First, to establish the existence of the estoppel at all, because it's one of the elements. Second, you have to calculate it in a rough and ready way to make sure that it's that the expectation value is not out of all proportion to that. But once it's fulfilled those two roles, it then drops away, and the actual remedy is designed to value the expectation that's been disappointed.
It is a question of looking both at the expectation and using the detriment to ensure that equity has a proportionate response to what has happened. And so from that is why Lord Justice Robert Walker talks about proportionality between the promise and the detriment. And that is why he also says in paragraph 51 that one doesn't simply look at the detriment suffered by the claimant. So where we are apart, perhaps, from the appellants in terms of principle, is that we would say that it is a very logical approach in some ways, and that's something that the courts, Lord Justice Lewison in Davis and Haberfield, and Lord Justice Henderson in More and More have accepted, that it can be an attractive way of looking at it just to take out the detriment, so that one loses one of the component parts. But that was something which in More and More, Lord Justice Henderson actually said, well, attractive as it is, it doesn't really deal with what equity is trying to do here, which is to look at the promise that has been made and to give effect to that promise if there has been detrimental reliance on it, but also then standing back and looking at the detriment that has been suffered to see whether or not that is a proportionate response. So the proportionality is, I think, as Professor McFarlane has described it, is negative in the way that the courts approach it. It's actually looking at the matter, it's a cross-check on the court exercising an equitable jurisdiction.
But the fact that it's become impossible actually to fulfill the expectation, you don't say, or you don't accept that is of itself enough then to push you onto a reliance loss based?
No, my lady, no, because there the court is still looking at the promise that was made and is looking at the detriment that was suffered, and in its broad judgmental discretion is coming to a proportionate response to what has happened. Because, and perhaps this case illustrates it, to simply compensate for detriment doesn't address cases such as this, where somebody has given up 30 years, the best 30 years of their working life, to work for a business they expected to inherit, but are never going to inherit. And so that is not something that the court can easily compensate for and simply ignore the promise that was made.
I'm sorry for taking you out of your way again, but proportionality, if one applies the minimum relief principle,
Yes.
Does that mean roughly equivalent to, or does it mean not out of all proportion to?
Well, my lord, I was going to come to the minimum equity next, and so because it's our submission that it's a phrase that appears in Crabbe and Arran District Council and the judgment of Lord Justice Scarman, but is an unhelpful phrase because it's been interpreted in a rather different way in subsequent cases. It's notable that in Crabbe and Arran District Council, it was very much the minimum equity to do justice to the plaintiff And of course, in Crab, effect was given to the plaintiff's expectation that he would have an easement over the local authority's land, so that his land that he wanted to develop wasn't landlocked. And in fact, some commentators have suggested that he did rather better than he might, his expectation.
Because he didn't have to pay for it.
Yes, he didn't have to pay for it. And the way in which that is explained is that the land had been sterilised for so long that effectively he had sort of paid for it. That's the justification, perhaps, for doing rather better than expectation. And so the minimum equity to do justice to the plaintiff can, in our submission, be read as doing what is required to do justice to the plaintiff and effectively vindicating expectation. And in some of the later cases, such as Gillette and Holt and Jennings and Rice, and also more recently in More and More, it has become synonymous with doing the minimum to do justice to the parties as opposed to the plaintiff. And there is in the bundle at page 1930 a discussion of the phrase by Professor Matthews, as he then was, Paul Matthews, where he says the phrase was turned on its head in subsequent cases and used to justify awarding less than the claimant's expectation. That's somewhere between reliance loss and the expectation loss.
Can you just give me a page reference for that?
Yes, that's 1930.
Thank you.
And also at going back to Jennings and Rice, and I can just give a reference for this, at 1090, the way in which Lord Justice Robert Walker described Lord Justice Scarman's reference to the minimum was that it does not require the court to be constitutionally parsimonious, but it does implicitly recognise that the court must also do justice to the defendant. So certainly there are Australian cases where the phrase has been used to mean compensating reliance loss. It has become synonymous with that. But it's quite clear from that particular comment from Lord Justice Robert Walker that it's certainly not, as a matter of English law, synonymous with the compensation of detriment. And that ties in also with paragraph 51 of Lord Justice Robert Walker's comments in Jennings and Rice that I took the court to, that the court shouldn't abandon expectations and look to the claimant as defining the appropriate measure of relief. So it's really our submission that the phrase, in a way, has been carried through into the cases in the way that it was never intended in Crab, and is really perhaps a twofold expression, either of the broad judgmental discretion that reflecting that there's an equitable doctrine being dealt with, but also perhaps the element of proportionality that it's accepted should be introduced. And it's notable, I mentioned the Australian cases where it appeared at one point, certainly, that there was a veering towards relying upon the compensation for detriment idea, particularly in Verveyen and the judgment of Chief Justice Mason. But in fact, it's very clear from more recent cases that, in fact, the courts in Australia have very much rowed back from that. And those cases are dealt with in our case. But in particular, Gemelli, which appears at 1595 of the bundle, and Delaforce, which is at 1566.
Sorry, what was the second one?
Delaforce, which is at 1566, make it very clear that that's no longer the law of Australia, and we would say it certainly isn't the law of England.
And the paragraph of your case, just for my note? You summarise all this in your case, I recall.
It is summarised. It is summarised in our case. Yes.
Can you just give me the paragraph number for my?
Sorry,
Don't worry.
I'll get my learned genius to look at it. I'm sorry, but the cases are, but they're all contained in the bundle.
Yeah.
Paragraph 25.
Paragraph 25.
25.
25.
Thank you.
And 50.
And 50, sorry.
And 50.
And 50 as well.
I can understand very well that there's a class of cases where the best way of avoiding inequity that would occur if, through somebody suffering a detriment in reliance on a promise, is to hold the person to their promise, and then there's no detriment suffered. And if that's not a consequence out of proportion to the detriment that would have been suffered, it may be the right thing to do.
Yes.
The problem in this case, it's impossible to hold the defendants to their promise.
Yes.
And so all one can do, as it seems to me, in this case, is to compensate for detriment that has been suffered.
But, my lord, the difficulty with that is that one gets into the problems of how to deal with detriment that is not quantifiable in terms of a financial benefit. And it's right to say that it was suggested there was only one option put before the court in terms of remedy, and that's not entirely true. There were two methods presented in this case. The first involved the parties living side by side, and the claimant Andrew carrying on farming. But it became very apparent during the course of the trial that was really not something that was going to be achievable in this particular family dynamic. Yes, it's right to say, and we accept this, that clean break cases have particular difficulties which attend upon them, as they do in many other legal circumstances as well. But it's our submission that as a matter of principle, just because the specific expectation cannot be vindicated, it's the reaction to that ought not to be simply to look at detriment and compensate for it.
But your route, which is then to look at the expectation, also brings with it huge quantification problems to get to the present value of an expectation that is some period it could be 5 years, could be 20 years in the future, to discount for all the things that could have happened in the counterfactual world where they didn't argue, that could have disappointed the expectation as well. I mean, how is one to start taking those into account when vindicating the expectation?
Well, my lady, in some cases, and I'm particularly thinking of the More and More case, where at first instance the judge handed everything or awarded everything to the son who farmed, leaving elderly parents dependent on the son for a small stipend every week of, I think it was £200, and for their bills to be paid by the son. So very much not a clean break, it's right to say. But and the Court of Appeal approached that by saying that there had to be appropriate provision for the parents, that they, because there was acceleration, there had to be appropriate provision made for them. But this case is rather different, because it is not that the parents are going to be left with nothing. They're going to be left with the lion's share. They're going to be left with their interest in the business, and they're going to be left with 60% of the land.
But in More and More was different, because you were ensuring that the claimant didn't suffer the detriment of having foregone all the other opportunities for his life by actually fulfilling the promise that he got the land, and then you had to make discounts from that. In this case, it is different, because you cannot fulfill that promise. He's not going to get it fulfilled. And so I can't see how you can do anything else in this case, reasonably, except for compensate for the detriment in order to make remove the inequity as best you can.
Well,
is there a possible middle ground, which is that where you can't fulfill the promise in specie by simply requiring it to be specifically performed, maybe you can look at the detriment caused by its non-performance and approach your calculation on that basis rather than simply on the detrimental reliance basis? Coming back to the Chief Justice Mason analysis of detriment, and at least one part of that paragraph of his judgment, though I accept if you read the whole paragraph, he is talking about the other detriment as well.
Yes. My Lord, that in a sense we would submit is what the judge has really tried to do here. That the judge appreciates, or appreciated during the course of the trial, that the parties weren't going to be able to subsist side by side. And of course, perhaps by looking at it solely from the impact that the order had on the parents, one perhaps forgets what the position that Andrew was put in as well, because if there had been no payment to him of that it's accepted, the judge used a valuation of the land to come up with that. And that would certainly accord with the non-fulfillment of the promise detriment. If Andrew had not been given anything, he is forced to, he is now an employee for the first time in his 50s. He doesn't own his own home. He doesn't have provision for a pension, all the things he might have expected. And so to award him a percentage value of the farm, which is what he expected, is in effect the way of compensating him, and it has due regard to what he expected to inherit. And of course, he lost the house he'd lived in for 30 years as well. It wasn't just the fact that he's employed for the first time in his 50s. He actually had to move out of the house that he'd lived in, expected to live in for the rest of his days, with his brought his family up in. And so the court effectively approached matters by compensating him, or that's one way of looking at it, compensating him for the fact that his expectation couldn't be fulfilled. And that is one of the ways which we would submit it was perfectly open to the judge exercising his broad judgmental discretion to come to in order to deal with what was a highly unsatisfactory set of circumstances.
The expectations in the future.
Yes.
And so I understand you to be accepting that you have to discount
Yes.
for acceleration, and you have to discount for the risks of life. And you say it's been done in this case.
Yes.
But that's what you say.
Yes, it is what we say. We say that the judge was very mindful of that. He says so in his judgment, that he knows that there is acceleration and that that has been done in this case.
And did he discount for the other risks of life?
No, but he would have had very much, it's our submission in mind, because he referred to the valuations, that this was not a circumstance such as More and More, where the parents were going to be left effectively without a substantial sum.
And if he had discounted for life, what would be the sort of discount you would recommend? Because somebody's got to work it out. What are the risks? You suppose you look at the risks in this individual case of the business failing, and you look at what? At the risks of old age, removing all the assets.
Well, my Lord, we say that was taken into account because he awarded 40% of the land when the promise had been of a substantial part of the land, which might have been more. He also made a liability for tax. He also granted a life interest to the parents. And he also knew that if the farm did have to be sold, that there would be a very substantial sum that was going to go to the parents, which the reality of which is that they were not going to be destitute in their old age, and that would, in effect, be sufficient.
And is that the test, that they're not left destitute by these proceedings?
No, I don't suggest for one moment that that's the test. But it's a factor that the judge is trying to do his best in a difficult circumstance where he's having to effect a clean break.
Well, the judge will therefore have reasons which reflect your submission, i.e. that is discounting for all the vagaries of life, the loss of the tax benefit and so on. Where exactly does he say that?
Well, he certainly refers in his judgment to the tax in relation.
What he says is it will not be achieved. That means he's left it out of account. At 287, surely that's what he means. The regrettable consequence of that conclusion, clean break, on my understanding of the parents' finances, it seemed almost inevitable that the mitigation of tax, which seems to have been in David's mind since around 2000, will not be achieved. But he doesn't go on to say that that's something he's taken into account in establishing 40%. For aught I know, 40% is simply his understanding of what a significant share would be, given there were other siblings who had to be catered for.
Yes, well, lady, he follows in effect largely the terms of the 1981 will, and he does in paragraph 287 say that he sees no reason why Andrew should not bear his share of any taxes, actual or notional, that are to be treated as the price of satisfying it.
But he doesn't say, for instance, and there should be brought back into hodgepodge the mitigation of tax, which is going to be lost if there is a sale.
Well, my lady, my answer to that would be that was highly speculative as to what will happen in relation to the tax. It's not clear.
Did the judge have evidence that it would not have to be, this farm would not have to be sold?
I can ask my learned junior.
No. It certainly doesn't refer to it.
Yes. No, he didn't, because
That would be speculation on his part.
Well, the difficulty, my lady, is that, of course, no submissions were made on behalf of the parents.
True, but the lack of evidence, whereas he had a void in the evidence, he couldn't speculate as to what was going to happen.
No.
And no doubt the parties had not dealt with that matter in the course of the trial.
What, my lady, there clearly was evidence was the likelihood or not of a sale. he clearly had evidence in relation to that. What he didn't have is assistance on any of the other matters, including the tax. But maybe this point is worth making, that if my learned friends are right, that in fact the way the court should approach this is by compensating for detriment, it's rather difficult to see how there would have been a better way of doing this. I mean, we haven't been able to calculate, for example, if the 360,000, and for reasons I've submitted, we wouldn't accept that was an appropriate way of satisfying the remedy in any event. But let us just take that as an example and add compound interest over the very long period of time, including some years of fairly high interest rates, which will, of course, have stopped in 2012 at the point where the partnership was set up, because at that point Andrew was able to pay to draw on the partnership. Then that could be a very, very substantial sum of money.
Has anyone had a go at the calculation over the short adjournment?
I think there was an attempt, but I think it needs a computer program probably to have a go at it. But we did try, but just a year, for example, of where there was an underpayment of 5,500, year one, produced a figure, I think, in the region of 30-odd thousand. So it's not...
The difficulty with that calculation is you'd have to do the same for Ross, and he was underpaid, and you'd have to do the same for David. He was... Well,
it's right to say, Miller, we don't accept, as far as David is concerned, that there was underpayment, because he was a partner in a partnership farming, so he may not have had a salary that was as substantial as Andrew's, although there wasn't much difference in it, but he was able to take drawings from the partnership. So it's an unfair comparison.
Can I just get my mind around one thing? The judge obviously proceeded, I think you're saying, on the basis of the 1981 will.
Well, it was a guide to him. I'm not suggesting that he followed it.
Well, the problem is we've got no explanation of how he did come up with the figures. There's a big gap in the judgment between the build-up to it, and then you go into the black box, and out comes the result. So we just have to try and reconstruct how he might have got to it in a logical way.
But if it was the 1981 will, there's no discount from it. Nothing for acceleration and nothing for the risks of life.
Well, apart from those points I've already made.
The life interest in the farmhouse would be potentially a discount. But apart from that, what other discount is there?
The fact that only half of the business that might have been expected to be inherited. And that's 250,000, my lord. So it's not an insignificant sum, particularly in the context of the sort of figures one's talking about here. So there was that discount, there was the life interest, there was also the having to bear the tax. So there was undoubtedly a discount from the judge in relation to the amount that he awarded.
Why would interest go back to 1982?
Milady, I'm sorry.
That's the earliest year in which the table shows an income differential.
Yes, he was 16.
I mean, it may be my fault. I just pointed to 1982 as the earliest year when we were looking at the matter before.
Yes, but doesn't it only run from the time when the promise that had been made is renounced? No. Would you say it runs through? I'm talking about interest only. I'm not talking about the differential in pay. But interest?
Well, if one is going to stand back at the point when the promise is broken and look back and actually compensate for the detriment, it would be my submission that one has to look at the interest that has accrued over that period of time. So, because otherwise one's not compensating for the detriment. And it perhaps, again, I've made this submission before, but we would say that there are considerable difficulties in compensating for detriment on this somewhat narrow financial basis. And that's something that Professor McFarlane very much recognises, albeit that he very much promotes this approach, as do other academics, to proprietary estoppel, that there are going to be cases where it is simply not possible to approach matters in that way.
When you refer to the broad judicial discretion, do you say that if the judge had gone about it differently and said, I'm only going to compensate for difference in wages and I'll add on something for disappointment and inability to build up a pension and buy my own house, do you think that would have been an error of principle, or would that have been within the ambit of his discretion?
It would be our submission that that would be an error of principle, and there is certainly in Jennings and Rice a statement by Lord Justice Robert Walker that that is not the appropriate way of looking at matters, that one shouldn't be looking, for example, at the hourly rates of a carer in that case to deal with the detriment that had arisen. And so, yes, we would say that would be an error of principle.
But that's because the person who came to be a carer, I think, in that case, wouldn't have been the carer if they hadn't relied on the promise. So that's not a very good measure. But in this case, we can assume, can't we, that the claimant would have been a farmer and he just wouldn't have had a farm of his own.
Well, it's rather difficult. Yes, your lordship's point's absolutely right. That if you've got somebody who is not going to be in that role, it is an inappropriate way of looking at matters. But it's equally inappropriate where you have detriment that is simply not amenable to the sort of financial quantification here.
Why isn't it, though?
Because...
Isn't it relatively straightforward in principle to see what the detriment is? That he's lost the opportunity of pursuing an alternative career in farming without his own farm. And it's not that difficult to quantify what he could have got out of that.
Yes, I mean, we would say that misses the promise. It misses the fact that he has been promised, and this is crucially important from his point of view, he's been promised the farm, or a substantial part of the farm in this case. He's been promised that he will take over the partnership, the share of the partnership business that he runs with his parents. He will be farming on his own account. And so it's our submission that that is the difficulty with simply compensating for detriment, that it misses what he has been promised.
Well, this is where I have the problem, because if the equity is that you shouldn't, if the inequity is through suffering a detriment, through relying on a promise, then you can either make things equitable by compensating the detriment or by fulfilling the promise. And in principle, it seems to me the minimum equity principle is you should give whatever is the lesser of those two.
But my lord, our point about that is that compensating the detriment, particularly in a case like this, where there has been an expectation over 30 years, somebody has worked extremely hard to build up a business which they expect to inherit, which they expect to be working in the later days of their career, it is really simply not possible to compensate. One might be able to compensate for lost wages, but it's simply not possible to compensate for the fact that somebody who expected to be farming on their own account, expected to be the farmer.
But that assumes he had an outright right to become the farmer. If he didn't, then what you're compensating is not that. You're trying to put him in the position as though he's not suffered a detriment by relying on that promise. And you can either do it by making good the promise or by eliminating the detriment, and you should do whatever's the least.
Well,
unless you can't tell, in which case you might, you know...
What's easiest?
What's easiest, what's most just in all the circumstances.
yes, well, we've made our submissions as far as what we say the minimum means, and we say it doesn't mean what it appears to mean. But perhaps our point is simply this. It's our submission that in circumstances such as this, you cannot compensate for, in effect, the lost years. It's not just financial. It's simply not being able to develop a career, to develop a life, buy property. He was clearly, as the judge said, or is, as the judge said, a hard-working and forward-thinking farmer. He took lots of extracurricular roles on, and it might so therefore it is impossible in our submission to compensate him for the fact that he has had his status effectively taken away from him in his 50s.
Well, I've never seen in any of the decided cases in this area compensation for such losses, quantification of them, but they are meat and drink in personal injury cases. Is no trouble in personal. Well, there's no trouble. It is addressed in personal. So why shouldn't there be the personal injury type valuations for that?
My lord, because there isn't. That there are very few cases where it is possible to point to them and say they are clearly dealt with on the basis of compensation loss, and that is because, unlike a personal injury case, this is an equitable doctrine. It is designed to affect the conscience of the person who has made the promise, and we would say that the primary objective of the equitable doctrine is to give effect to that promise, unless it would be disproportionate to do so, and that is how the cases deal with matters. And they deal with them in that way because it is, in our submission, extremely difficult to quantify the loss somebody suffers when they have predicated their whole life on a particular basis and the rug is pulled from under them, that their life is no longer going to be lived in that way.
One doesn't know, for example, whether he might have followed in his father's footsteps, who didn't inherit the ownership of the farm, I seem to recall. He was only a tenant, or his father had only been a tenant of it.
Yes.
So that striking out on his own, Andrew's father actually managed to run the farm in such a way that, presumably through a mortgage and making mortgage payments, he became a farmer, even though he didn't start out as one.
Yes. Yes. I mean, he could have... there is nothing to suggest that somebody who had the talents that the judge found that Andrew had in the judgment could not have made a very successful farming life for himself. He chose not to. He chose to put his energies into the family farm, and he has effectively built it up for, as the judge said, his siblings to inherit, and that is not what he ever expected.
But what's the policy going forward? Should this court be encouraging this kind of situation to arise in future, or should this court be sending out a signal that sons and daughters should be paid the proper wage for what they're doing, and that if their parents try to say to them, oh, well, get up every morning at 5:20 and milk the cows for the next 30 years, and we're not going to pay you because we'll leave it to you in our wills, the son or daughter says, well, no, I see that doesn't actually work. I want you to pay me properly for the next 30 years. I mean, where does the policy for this lie going forward?
My lady, I think the difficulty is something that my learned friend averted to this morning. For most family farms, it is extremely difficult for there to be payment of a substantial wage. And so, in a sense, there's a practical problem, perhaps not a policy problem, about that. But of course, there are cases where, notwithstanding that a child may have worked on a farm, that the court finds no representations have been made. And for example, the James and James case, which is in the bundle, which was a decision of His Honour Judge Paul Matthews sitting as a High Court judge, was a case where the claim failed on every basis, on the basis that no representations had been made. And it's not really the failure to pay a proper wage that is the problem. It is the fact that promises are made, and in reliance on those promises, the child of the farmer acts to their detriment. And the fact that those claims were right in law, of course, was established in Thorner and Major in 2009. So, in a sense, it is about guidance as to how the courts deal with satisfying the equity. And it is perhaps one of the reasons that so many of these cases seem to have got to the Court of Appeal in recent years is the fact that there has been this lively academic controversy, that parties have formulated appeals based on that lively controversy, so that the court has the courts have been faced as to the principle of whether or not they compensate for detriment or alternatively give effect to expectation. Interestingly, in none of those cases has the court ventured a view, and in my submission quite rightly, because the court has looked at the court has very heavily taken into account expectation, as it has done in almost every case.
When you refer to is there a good example of an academic supporting the expectation measure? Because all the ones I read, McFarlane, Robertson, Snell, they're all supporting reliance.
Well, look, can I say that perhaps Snell, because Professor McFarlane writes the chapter on...
Right, okay. Maybe they're all McFarlane, but...
So it may well be that there's only one tick in that particular box. Robertson is not, in fact, totally in favour of the compensation loss basis, because he sees the difficulty of actually it working in practice. So we would say that he is somebody who can see the logic of it. But Professor Elizabeth Cook, whose law of modern equity is in the bundle, is someone who espouses the view that actually the courts shouldn't adopt the approach of compensating detriment, where in fact, in order to protect against detriment, in most cases, one has to give effect to expectation.
Thank you. Let's look at that.
Is that just for the point of view of calling a spade a spade? In the sense that, in truth, if you're giving effect to expectations, you are to some extent really just dealing with the detriment caused by that and the reliance upon the promises.
Yes. Well, I think probably Professor Cook actually has a rather more principled defence of expectation than that. Certainly Professor McFarlane acknowledges that, in fact, none of the cases really follows or few of the cases really follow as a matter of principle compensating detriment. And so perhaps then
The nearest you get, I suppose, is Lord Justice Lewison expressly obiter
yes,
on the point.
yes.
But I might think that Lord Justice, later Lord Walker, is the sort of judicial granddaddy in this area of the law, from whom I suppose you would say you derive some help.
Yes.
In the way partly in the way you've illustrated.
Yes, and my lord, he was in so many of the cases. He was
Yes.
In Gillette and Holt and Jennings and Rice being perhaps the most important of those. But going back to Lord Justice Lewison, it's notable in the two cases in which he expresses enthusiasm, or maybe that's putting it too high, for the view expressed by Professor Macfarlane. In Davis and Davis, he didn't. That was a case where the judge at first instance had awarded 1.3 million to be paid out of the family farm, which I think was worth about 4 million, to a daughter who had rather intermittently worked with her parents. It's a very, very different case from this, and had fallen out with them on a regular basis. And by the time that she returned the last time, really had only an expectation to have a home for life as opposed to a farm. And there wasn't any question before the Court of Appeal as to whether or not a monetary compensation was appropriate. Everybody agreed it was appropriate, and the only question for the court was how much. And the Court of Appeal reduced the 1.3 million to 500,000 on the basis of the expectations being that there would be a home for life. As far as Haberfield is concerned, Haberfield shares many things in common with this particular case, in the sense that it was a case where a daughter had been promised a dairy farm by her father and had worked on the farm for 30 years, and the court ordered that a substantial sum of money be awarded to her, which was going to result in the sale of the family farm. And there was no suggestion in that case that it was detriment loss that was being compensated for. It was very much expectation. And indeed, Lord Justice Lewison dealt with it on the basis that it was a sort of quasi-bargain case, because the father had wanted his daughter to work on the dairy farm and to continue the line farming, and she had done that for 30 years.
Well, could it be that the real principle being applied is one of proportionality? It's just that when the proportionality takes you to a generous result from the point of view of the claimant, that one might then say it's more like expectation or quasi-expectation, but that the real principle that's going through the judicial mind is proportionality.
Yes. Well, my lady, we do say that.
It rather sidesteps the necessity to have to say it's either detriment.
Yes. Well, yes. I mean, in a sense, it's an academic controversy that judges seem to have been very reluctant to get involved in, and perhaps Lord Justice Henderson in More and More says, well, it's very attractive, but actually, where you're dealing with proportionality, perhaps one really doesn't have to go there.
But the message then ought to be the principle is proportionality, and you should reason it out as a matter of proportionality, not just do the sum and then expect everyone to guess how you got there, because that makes it unappealable, or can make it unappealable. I'm not saying this case, but in another case could make it unappealable, and certainly the parties won't know why the judge came to that figure.
My lady, yes.
Which is contrary to the principles of judicial reasoning.
Yes. My lady, I think the judge in this case, to defend him, did set out at some length between, I think, about paragraphs 144 and 165 of his judgment, the principles that he should bear in mind. So he did actually analyse the law and referred to the lively controversy in some detail.
It's a very, you've got to read the judgment as a whole, absolutely.
Yes, it's not just when one gets to paragraph 288 that it is that earlier reasoning where he goes through the law and goes through the law in some considerable detail, including looking at this controversy.
And the problem, if there is one, is the lack of a, as it were, linking passage showing how the law, as he's analysed it at very great length, leads to the result to which he came.
Yes.
Plumbing it back into the statement of principle.
But my lord, I would say you have to read the judgment as a whole to see where he gets that from. Well, I'm conscious that I don't have very much longer. Might I just have a moment?
We've been battering you with questions, but you ought to have a little time just to see what you want to say further orally off your own bat.
Do that.
Could I just ask, just before you finish, the same question that I asked your opponent, which is that if we were minded to think that the judge had made an error of principle so that his order couldn't stand, what do you submit we should do about it?
Well, look, can I say, and perhaps this isn't a very satisfactory answer, it rather depends what the court is proposing to do. But if it was if it was a solution that required any further valuations or computations, then of course we would ask for it to be remitted and say that was really the only way in which.
So you're not saying avoid remittance at all costs? I'm just conscious that this must be costing this not particularly wealthy family,
yes,
to use a colloquial phrase, an arm and a leg.
Yes.
And if, for example, both parties wanted us to, as it were, do the best we can on the materials available rather than incur everybody in further costs, we would, I think, probably be at least sympathetic to thinking about that.
Yes. If there was adequate material, then I'm sure the family would, certainly my client would welcome that.
Yes, okay.
Because, yes, it's undesirable for this to go on. Unless I can assist.
Well, thank you very much.
That's really... No, can I also echo what has been said by Ms. Reid there, that we're prepared to offer you any more help if you need it. but my clients would very much value this matter being really drawn to an end as soon as possible. Probably even more for human reasons than for the cost, but the cost is still very significant. Absolutely. Still very significant. Yeah. So entirely accept that. Can I just whiz through a few points that I noted down during the course of the Miller submissions? I take them almost in reverse order, but Lady Arden raised the point of, does this all just come back to proportionality? And of course, proportionality is, I think, as we submitted, central to the evaluation. But one does need form in order for the proportionality to be applied. You need to know what it's proportional to, and also, in my submission, proportionate is still a difficult term, and it would be more satisfactory in my submission to have a term that leans towards equivalence rather than proportionality, because, of course, 10 is proportional to 100 by a proportion of 1 to 10. But that doesn't give you any answer whether the proportional is that in this case.
Yes, but we don't mean proportional in the sense that you've just put it, do we?
No. As soon as I said it, I thought, oh no, what have I said? They might think I'd said, no, we don't. There's reference to Davies. The interesting thing about Davies, there was a reduction in the Court of Appeal. The judge apparently had overcompensated the claimant at 1.3 million, and that was reduced to 500,000. Interestingly, the 1.3 million the judge fixed on appeared to reflect the terms of the will of the father, up until the point where the family fell out. He seemed to get it from there, and the court obviously thought that was not the appropriate way to look at it. Again, going backwards, Professor Elizabeth Cook, she may now be Her Honour Judge Cook, in fact. But I draw attention really to the fact that while I have huge respect for her, she was a law commissioner too, and her full career. That is a 2000. That was published in 2000. That book, and a lot of water has passed on the Estoppel Bridge since the year 2000.
Well, except that it doesn't seem to have resolved the lively controversy.
No, well, that goes back even further. Lord, yes. The next point to make is that there has been, as I understand, no evidence, or really even argument in this case, certainly at trial or since, that Andrew could ever have afforded to buy a farm himself. It's raised as a possibility, I understand, by my own friend here, but in my submission, if one tries to assess that, that must be unrealistic.
You mean in the counterfactual world where he left the farm at 16 and worked somewhere else?
Yes, absolutely. Well, it would have been later than, yes.
Yes.
It would have been later than 16 because he wasn't made any assurances or representations at that stage. It would be substantially later. But yes, it's true to say that my client David was able to buy at the age of 19. He was offered the property, and he managed to find a mortgage that would do it. But that was in the mid-60s. Agricultural properties are much lower value at that point.
Would it not be enough for him to rent?
Yes, for the counterfactual it would. Yes, it would. But then he would not be in the counterfactual where he would. There was some prospect of him inheriting.
Yep.
So that would substantiate the comparable figures he might make. But
I mean, he could have been a tenant farmer,
yes,
making up his own mind how much he paid himself rather than receiving a wage, but paying rent.
But paying rent. Yes, yeah. Yes, exactly.
I don't know what sort of rights of succession or anything are built into a modern
Currently none. You get a farm business tenancy nowadays, which has farm business tenancy nowadays, which has no right of succession. Right. I think they stopped about the 80s. The succession rights from recollection. Yeah. Odd enough.
Just about when he was starting.
Yeah, 95.
95. I'm very grateful. 95. Just about the time when the assurances were being made.
Yes.
Yes. I said that David, my client, went in to see his landlord Enoch. Enoch Williams, get it right. When he was 19, he might have established a succession tenancy at that point, but probably didn't know about it. My learned friend says that Lord Justice Walker in Jennings and Rice said discouraged looking at the sort of rates a carer might charge for trying to assess the reliance loss, as it were, or the appropriate payment. But in fact, although he discouraged that, he did cross-check to it and said that that did help to justify the £200,000 award that had been made in that case. So he spoke with forked tongue on that one, I'm afraid. My learned friend also mentioned a couple of times that a substantial inheritance